Correct.
No, I'm recording in the cloud. So let's search for it. Let's see.
Close.
So, well, first of all, let's say the date. Today is the 12th of October. Is our sorry, it's the 6th of October. It's our 12th lesson.
Yes.
This is the advanced course of legal English. And, well, we are dealing with a new topic now. From Unit 5, we have had lots of fun with employment law, haven't you?
Yay.
I know you have.
Yes.
Yay.
You're not gonna tell it. You're not gonna say it, but I know you have.
Yes. Tort law.
Very good. So, but today we are dealing with the topic tort law. Does anyone know what tort law is about?
Romy and Maria, perhaps. Romy or Maria?
We had a lesson of tort law a few weeks ago, I think.
My part.
With Adela.
Yes, some part from tort law. What does tort mean? What does tort mean?
Era como el derecho civil.
Yes, it's not torta, it's not tortura.
Although I would love it for it to be torta.
It means
I truly miss tortas. We used to have tortas in the legal English schools.
No.
We used to.
It means tortious.
Tortious. Yeah.
Algo torcido, algo wrong, something wrong. That's where tort comes from.
Right, very good. So we're going to learn some new collocations. Remember that tort law was about a duty that we possess not to harm other people. That was the main basis for this type of legal English. So first of all, let's start with some, it's recording, yes, it's recording. First of all, let's start with some, it's my greatest fear, with some collocations. Who else is there? I don't know.
Maria Victoria.
Maria Victoria, can you read? Vicky, can you read? Or Maria.
Maria Costanzo.
Juan Ignacio.
Okay, to provide a remedy.
Provide a remedy. Everyone, what is a remedy?
Some compensation.
Is another word for compensation, yes. Very good.
Yes.
Who else is there?
Tatiana.
Tatiana, can you read?
To be entitled to damages.
Damages, yes. Very good.
Impassive.
So, to be entitled to, yes. Yes, I think there is no ing form of the verb to entitle.
No. And no active voice, because you cannot say I am entitling or right. I entitled. No, it's always in passive voice. I'm entitled to. It's passive voice.
Damages. Well, another interesting verb is to award damages, and so you are entitling someone to. No, sorry, I'm wrong. You're making someone being entitled to damages. So damages is the same as remedy and also as compensation. So Juan Ignacio, can you read the next one? It's the same as what I have just said.
Yes, to award damages.
So now you know, all of you, to award.
Award.
In general terms, what does it mean to award?
Win something.
Well, you win something and somebody awards you.
Right. It's not the same as to reward someone. Although, yes, it's not the same as to reward someone. But well, that's another part of the language that practically no one cares about except me.
Well, but the thing is that who can award damages? Who can award damages? That's a good
The
question.
judge.
A judge,
judge.
an authority, an authority.
Yes. Now you can see the judge is entitled to award damages.
Awarding damages.
Yes, entitled to awarding damages. Oh,
Yes.
well, depends on your
Well,
choice. Very
the
good.
claimant, the claimant is entitled to damages, and the
Entitled to.
judge awards damages to the claimant.
Right. Vicky, can you read the next one?
Yes. To incur expenses.
To incur expenses.
Incur.
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 Incur. It's a little bit poetic. Incur expenses.
Incur
Like
expenses.
French. Incur.
All of you, to incur expenses.
Incur. 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 Con el piquito. Incur. Incur the expensive.
Okay.
All of you do it. It's just, it's simple to incur.
To incur expenses.
Incur.
Incur expensive.
Yes, the first time is not gonna be so so clear. Only with repetition you can do it. Very good. Is there another one? I don't remember.
Tell
No,
us.
there isn't.
No, there's no.
Right. Maria, can you read the next one here?
Yes. Loss of earnings.
What would be loss of earnings in Spanish? In a
Procesante.
lucro cesante, exactly. For Tatiana, who's not a lawyer, Romy is not a lawyer, but I think that she understands a lot. Understands a lot. Loss of earnings is lucro cesante, que sería dejar de percibir riquezas o entradas que tendríamos que percibir debido a un daño causado. Loss of earnings, lucro cesante. Exactly.
And be careful, it's not loss with a final E, it's with a final S.
Loss.
Or lose with double O and final E. It's loss here.
Loss.
It's a
Pérdida.
very common mistake.
Loss.
Because they are more or less similar and they sound the same. I don't know why they made such a difference. Okay, who else is there? Romina, is Romina there? Yes, she's there.
Yeah.
Can you read the next one?
Yes. To act as a deterrent.
Deterrent.
Deterrent. It's not detergent.
No.
Oh, sorry, I thought it was a good joke.
I laughed.
Yes. Someone. Right. To act as a deterrent. Everyone tell me, what is a deterrent?
Don't know.
Does anyone know?
Es algo como para persuadir.
Para
Disuasor.
prevenir,
Para
prevenir y hacer que no hagan algo.
Okay.
That's a deterrent. I think that it does not have an exact translation. Deterrent. You deter, for instance, las astrintes act as a deterrent for the ones that owe money, not to delay payment. If they delay payment, they're going to pay more because of astrintes.
There is a direct translation. Disuasivo.
Disuasivo. Perfect. Perfect.
So there is a translation. That's deterrent.
Excellent.
And therefore the verb to deter as well.
Deter.
Deterrent. And so, you know, it's to act as, maybe to behave as it could be, but I'm not sure. So don't use it. Although I don't think you're not going to use it.
No, because a deterrent is something, not somebody. Deterrent.
Yes, very good. To act as a deterrent. So now you know it's to act or not to do or any other verb.
No. Act as.
So
deterrent.
you have let's see. Is there? I think there's another one. Who else is
María,
there?
María
Juan
Constanza,
Ignacio?
María Victoria.
No.
Yes.
We have now the funniest, my favorite part, prepositions. And so we have, sorry. Juan Ignacio, can you read the next one? The first one.
I think
yes.
that there's a typo there. It's to be liable for something.
Sorry, to be liable for something. I forgot one
To be liable.
word.
Yes.
To be.
Okay.
Yes, to
Okay.
be liable for something. So now you know it's for something. Who else is there? Can you read the example, Juan Ignacio?
Yes, you are liable for the results of your breach of duty of care.
Care, yes.
For. You're liable for.
Maria, can you read the next one?
Yes, to depend on something.
Now, does anyone know the difference between depending on and to be dependent on? Oh, sorry. Tell me, does anyone know? Or, well, don't worry. Let's move on.
Be dependent.
To be dependent on or to depend on. No, sorry, to be dependent of and to depend on.
I think that it's
That's,
the same thing from two perspectives.
yes, and one is from the other perspective and the other one is from my perspective. So, Maria, can you read the example?
Yes. And the amount of damages awarded will depend on the amount of earnings you have lost.
Okay. To depend on something. I think that he's kicking out the cat.
No,
not.
don't worry. It's just my cat, but I'm not sure why.
Well,
Yeah.
go on, please, go on.
The
To the
amount of
cat.
damages awarded will depend on the amount of earnings you have lost. So now you know it's to depend on, not depend in or under or any other preposition. Okay, who else is there?
Romy, Maria Victoria,
Because I have
Tatiana,
several Marias and
Tatiana.
we have, well, maybe Tatiana. Can you read the next one, Tatiana?
Yes, under certain circumstances.
Excellent. Under circumstances. Under circumstances. That's the preposition.
Circumstances.
Yes. Excellent. And the example.
Excuse me for a minute.
Oh, he really has trouble with the cat. Sorry. I cannot click on it. Thomas, come back. Today I had an exam, online exam of lógica jurídica, and all the students should have the
Both.
microphone on, and all the dogs were barking all the time. Terrible. Terrible for us that we were sitting for the exam. Thomas, go on, please.
Yes, very good. So under certain circumstances, under is a very formal word. So I advise you all to use it whenever you're writing something.
Circumstance.
You're drafting. You see, that's the verb. Something in legal English.
Okay.
So, Tatiana, can you read the example?
Yes, under the circumstances, your client is at fault.
Is at
Fault.
fault.
Interesting.
So in the
At fault.
circumstances,
It's something you
client-
don't often
yeah.
hear.
At fault. That's
Alright, is
another
there-
preposition. At fault. At fault. At
Well,
fault.
that will be for another time.
Yes.
At fault.
At fault.
Right. Is there another one, maybe? Yes, there is.
Bright color.
Yes, yeah. I'm the master of presentation.
Colors. Okay.
Colorful presentation. Yes. Vicky, can you read?
Yes, to be entitled to something.
Sorry, there's a typo there. Don't worry.
Entitled.
To be
Entitled.
entitled
Because it's
to. But in
entitled.
this case, we're not actually talking about the collocation. We're talking about to here.
To.
¿Cuánto necesitas?
Yes.
To be entitled to
To.
something. So, I mean, we are teaching you to focus on prepositions because trust me, they are really important. And I'm not sure if in the examination there is an exercise about it.
There are lots of exercises on prepositions and
Well,
collocation.
so now you know.
related to
My
prepositions.
work will bear fruit. You see, that's
Okay. Go on,
another-
please. Go on.
uh,
The example now.
come on, why are you so rushed? Well, very good. So, Vicky, can you read the example?
Yes, my client is entitled to redress.
Redress.
Everyone, tell me what is redress because we're going to have a listening about it afterwards.
Okay. Redress.
Compensation?
Yes, it seems to be to redress, revestir, ponerle el vestido de vuelta.
O volver al estado anterior.
Exactly. In fact,
Okay.
it's an idiom in Latin.
In Latin, we have the expression resilio. That's what it means to go back to the previous state. That's why in physics, certain elements have something that is called resilience.
Okay.
It's
Well,
the ability
in this case, it's a Latin expression, a Latin phrase, but I don't remember the Latin.
expression. So redress.
Es volver las cosas al estado anterior. Status quo ante. Status quo ante. Yes.
I didn't know that.
Yes.
Interesting. New word for me.
That's why you redress the person.
Redress.
Yeah,
Which would be is there a similar expression in Spanish as well? The word redress, do we use, which is the expression that we use when we talk about redress?
Tell us.
No, tell me, you.
Well, I'm waiting for what?
Just a word? I don't know.
Yes, in
Or
Spanish.
is there a whole expression?
Compensation. Yes, an amount of money.
For an amount.
Daños y
Yes,
perjuicios.
but I'm asking for the word
Compensación.
in Spanish. The word in Spanish.
Compensación, volver las cosas al estado anterior.
Right.
Indemnización.
Indemnización.
Indemnización. Very good, yes.
Okay.
Okay, is there another one? Sorry that
Yes,
I forget
definitely.
the sequence.
Okay.
Very good. Yes, there is one. Who else is there? Juan Ignacio, maybe. Can you read the next one?
Yes, to have a duty to another person.
Can you read the example?
You have an automatic duty to every other citizen not to cause them harm because of your conduct.
Yes, and you also may use to owe a duty. To owe a duty.
No, a duty.
Owe a duty. A duty of care.
Or a
Owe a
duty.
duty of care. Como que adeudan. Owe a duty of care.
Very good. Romy, can you read the next one?
Yes. To cause harm to someone.
Can you read the example?
Your client's negligent conduct was the cause of the harm to my client.
Cause the harm to someone. To someone.
Do we use the same preposition in Spanish? Hacia el cliente, hacia el demandado, hacia el demandante.
El daño al demandado. Al cliente.
Demandante. Sorry, do we use the word demandante or client?
Demandante, el cliente desde el punto de vista del abogado y desde el punto de vista procesal es el demandante.
Right, interesting. Very good. I think there is no other one.
Okay.
No, there's no other one. So let's, were you, as always, I'm going to ask what I always ask. Were you able to download and work on the material that I uploaded?
On the platform.
Yeah.
Yes.
And you didn't send it by WhatsApp because
I
Tatiana is not
sent
going
it.
to have it.
I have it right here. I have the text
Okay.
message I sent all of you right
Mm.
here because I learned from you. Always present the evidence.
Okay.
So I have the evidence right here. And if you are at fault, where is at fault?
At fault.
Where is at fault? Let me tell you. If you are at fault.
And the thing is that, for
then
instance,
you-
if you didn't send it through the WhatsApp group, I didn't send it to Tatiana, who's not in the platform.
but I sent it through the WhatsApp group. I always do it.
I didn't.
Because
didn't
you told me people tend to look at it, and people said thank you. So I know
Okay.
people read the message
see.
and they knew. I know they knew.
Ah,
Right,
well, go on, please.
right. The thing is that I get tired of justification,
Okay.
or sorry,
Inactivity.
that's a kind name for excuses. So
Okay. Listening activity. That's one that says listening activity, please.
but that's the final activity. Do you want me to start with it?
I don't know. You told me now that you have sent the sheet of paper. So I sent it to Tatiana. Well, go on, please, Thomas.
Right, very, very good, because
Okay.
I always get scared. It's recording. Yes, it's recording.
Okay.
I think so. Yeah, sorry, is that I'm searching. I'm
Okay.
trying to see.
So it's a Jamboard. You may share the Jamboard.
Right. I'm going to share it with you. Don't worry.
Okay.
Right. Yes. I'm still getting used to Zoom.
Oh, modernize
After
it.
so many months,
So
I'm still getting used to Zoom.
Jamboard. The Jamboard is on the chat. I will go for it.
Right. Remember that. Oh, you can be edit. Remember that you can join if you want to, but it's a nice gesture if you joined. So.
Okay, I'm there.
So, for example, do you see this?
Yes.
Yes, yes, I see.
Very good. So we're going to read a little bit, as always. My favorite type of exercise.
Yes. Remember that all of this is part of the Tools book.
Yes, this is part of the Tools book.
Yes.
We are done with funny activities and entertaining material with interesting learning.
Don't scare them, please.
Very good. Very good, but it's good. And Eddington's. All right, Maria, can you read the assignment? Okay. Everyone go to frame number 2.
Yes. Exercise 1. Anne Eddington's second lecture on the law of tort is about tortious liability. Here are the notes that Anne has prepared for her lecture. Read what Anne is planning to say to her students about tortious liability and decide whether the statements that follow are true or false.
True or false, blah, blah, blah. Everyone tell me, what is tortious liability? Do you remember? Does anyone know?
A person, I think that I remember that it's that a person could commit a tort.
Yes, in fact,
they call them
liability is a person may be sued. Is the possibility that a person is sued because of a tort.
or he or she committed a tort.
Yes, yes, yes. It's more or less responsibility, but the idea of responsibility and the possibility of being sued, that's liability. And tortious liabilities, the possibility to be sued because of a tortious fact.
Tortious.
Okay,
Tortious fact. That's
tortious.
interesting.
Yes.
Right. So let's. Okay, Mickey, can you read just for a while? Do you see this? We are on frame
Yes.
number 3. All of
Yes.
you.
It's very difficult.
Okay.
Do
Okay.
I read?
Yes, lecture notes.
Yes.
Yes.
Tortious liability. It is very difficult to give an exact definition of what a tortious liability is. Lawyers and academic rights do not seem to be able to find a clear definition upon which they are agreed completely. In general, it is liability for harm that is caused to another person, caused
Yes, Vicky,
to
it's
another
caused.
caused
And also, everyone, I think many of you know, this is pronounced liability. Liability.
Liability. Yes, liability. Cause.
It's so that you don't get confused. So
Liability.
that it's caused.
liability for
Yes.
harm that is caused to another person due to a breach of a duty of care. Let us now look at some important aspects of tortious liability.
Okay.
Very good. Maria, no Maria Victoria. Maria Costanzo, can you go on?
Yes, some tortious liability arises from the common law and some from statute. Shall I go on?
Yes.
Statutes. Yes, go
Okay.
on.
All citizens within a particular jurisdiction have a duty of care automatically imposed upon them by the law of tort. In this way, it is very different from contract law, in which the parties to a contract assume their obligations voluntarily. For example, the law of tort in England imposes an automatic duty upon every citizen not to go onto anyone else's land without his or her permission. There is no need for any two individuals to agree privately upon this. The parties concerned might not have had any contact with each other at all before the tort of trespass to land is committed. In this respect, it is much the same as in criminal law.
Wait
Excellent.
there. Juan Ignacio, can you go on with the final part of the frame number 3?
The law of tort will impose liability where a person has acted in a certain way or failed to act in a certain way if the law requires it. This means that liability in the law of tort can arise as a result of either an act or an omission.
Act or an omission, yes. Very good. Wait. Right, so everyone go to frame number 4. Do you all see this?
Yes.
Yes.
Yes, very good, yes. It's recording, yes, it's recording. Sorry.
Yes,
It's I get obsessed. Very good, Romy, can you read this part, the first one here?
Yes. It's also possible, according to the law of tort, to be liable for the acts or omissions of another person with whom you have a certain relationship. An employer, for example, can sometimes be held liable for the acts or omissions of his or her employees. This type of liability is called vicarious liability.
Vicarious liability, interesting. Tatiana, are you there? she there? No. Yes, she is.
Yeah,
Can you
yes,
read this part here?
same. Most of the tort claims that are brought are based on fault. This means that the defendant has done something wrong. This fault can consist of having an intention to commit a wrong, but negligence is often,
Negligence. With an A. Negligence.
negligence is often enough to establish fault.
Very good. Wait there, Tatiana. Can someone tell me, is there anything similar to negligence or being at fault or having intention in the Argentine legal system?
Tell us. Negligencia, exactly.
Or
Culpa,
omission. Do we have something similar to tort?
daños y prejuicios.
Right.
Is the same that the omission and negligence.
Omission is when you omit something that you owe to do. Is an owe is something that there's a duty of care and you omit it. And negligence probably is because you are a professional and you have
You're
omitted
careless.
one of your duties. Is more related to professionals and some rules in the profession.
Yes, a little bit with ethics as well.
Yeah, maybe.
Perjurio is this? It's similar as well with omission, or sorry?
No,
with,
no. Perjurio is bad talking about somebody. That's perjurio. Or perjurio is lying under oath. That's perjurio.
On the oath. Interesting.
Okay.
So it's similar. So it's more like slander. Would it be?
Yes, remember slander. Yes.
Slander. That is also another example of tort. So let me
Yes.
write it down here for you.
In which slide are you?
I'm in frame number 4.
Frame number 4. Yes.
They are
Excellent.
not slides, they are frames.
Okay.
So
Sorry,
be
Tomás.
careful.
Is
Right.
slander is the same as tort?
No,
It's a form of
slander
tort.
is one, how do they call it?
One crime,
Is
in fact.
one crime within tort.
And it could lead to a tort,
Okay.
lawsuit because of slander.
Sería una calumnia, ¿sí? O al decir algo,
Okay.
alguna
Defamation.
difamación.
Slander,
Defamation also exists, but I think slander sounds a little bit more cool. Sorry,
no.
that's my cooler. Yes,
Okay.
that's my explanation for almost anything. Okay, who else is there? Maybe Vicky, can you go on reading right here?
Yes.
Some tort.
Some torts are based on what lawyers call strict liability. This means that there is a liability in certain situations independent of any fault. The defendant in any situation, known as the tortfeasor, will be
Yes.
liable.
Tortfeasor.
Tortfeasor. Miss Feasor, Thomas Feasor, tortfeasor.
All right, so let me just check it, maybe because
Okay.
I'm not so sure.
I think it's tortfeasor.
Let me just I'm checking. Wait for me,
Okay.
and then I'm going to share if there is
Okay. So
yeah, sorry, because I need to share.
so it was tortfeasor.
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 Can you listen to it?
Tortfeasor. Yes.
Tortfeasor.
Tortfeasor. Okay.
Yes. Sorry, let me just right here. Sorry, is that
Okay.
so?
Tortfeasor. I go back to the Jamboard.
Yes, yeah, sorry, is that it's hard to go back. Oh.
Yes, yes. I know that.
Okay.
So number four,
Tortfeasor.
frame number 4,
Frame
Tortfeasor.
number 4, yes, Tortfeasor.
Yes.
I had always thought it was
defendant-
Tortfeasor.
No, Tortfeasor. Don't repeat it the wrong way.
So that's why I said I had always thought, but now I know it's Tortfeasor.
Tortfeasor.
Well, go on, Vicky. Tortfeasor will be liable.
The tortfeasor will be liable even though harm to the claimant happened without intention or negligence. For example, let's say a defendant keeps something on his or her land that is dangerous, such as a harmful chemical. The chemical escapes due to not fault of the defendant and causes harm to the neighbors. This is called a breach of strict duty. The defendant is liable even though he or she is not at
fault.
At fault.
At fault.
Wow, you can be liable for anything.
So what is strict liability for us in Spanish? ¿Responsabilidad qué?
Subjetiva.
Objetiva.
Objetiva.
Strict liability, responsabilidad objetiva.
Objetiva. Es lo que era antes de 1113 y ahora es 1057.
Claro, que no es ni culpa ni dolo.
Sí. Objetiva.
Interesting.
Okay. Strict liability. You don't need to demonstrate, to verify negligence, or well, perhaps negligence, but not that you are guilty of something. You just show the facts and there's strict liability. You are responsible.
That's it. That's all they need for you to
Yes,
be
for instance,
worth damages, because that seems too little.
Yes, you own a car, for instance, and you give your car to your brother, and your brother goes on the streets and he crashes on someone. And even though you weren't there and you're not guilty of anything, because you are the owner of the car, there's strict liability, and you are the responsible for the crash and the tort consequences. Okay, most tort.
So now you know, never share your things.
No, come on. Most torts. Maria,
all right. Romina, can you go on?
Romina, okay, Romina.
Yes. Most torts require proof of damage suffered. In addition, that damage must not be too remote as a consequence of the defendant's behavior. However, some torts do not require proof of actual damage. Libel is an example of this. If I write something about someone that is not true, that person does not need proof of damage to bring an action against me under the law of tort.
Libel. Libel is one form of defamation.
Defamation, yes. Libel, very good. I think there is a little bit more, I think. So now let's go to frame number 5 and let's do the true-false activity.
True-false activity.
I recommend that you take a picture of the frames number 3 and 4. Okay. I know it's a lot, but trust me, I couldn't make it any bigger. Okay, or maybe you can just tell me, I read and you tell me true or false. According to English law, the liability that arises in the law of tort comes from both statute and the common law. Is that true?
I think it's true.
Yes, I think so.
Common law and some from statute. Yes, very good. So it's true. Let me just highlight it. Very good.
Excellent.
You can always do it yourself as well.
Okay, I will do that. Go on, please.
I will. Right. It says, letter B says it is possible to bring a case against someone under the law of tort without having any kind of private agreement or contract with that person.
I think it's true.
True.
Yes, yes, it's true because it's
True.
tort without a contract, a previous contract. True.
Contract.
So I circled true. The next
Very
one.
good, true. And letter C says it is impossible to be liable under the law of tort because you haven't done something. I wish it was true.
False.
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 False because there's omission.
Yes.
There's a mission. Yes.
Next one. I did that.
Yes, don't worry.
Now okay.
And D says it is impossible to be liable for the actions of another person under the law of tort. I wish it was true as well, but it
But
seems
it's
that it
false.
is false.
False. So it's false again.
But you can never foresee that someone is going to do harm with something related to you.
But sometimes you're responsible for that, for others, for the behavior of others.
But I think that you cannot foresee sometimes that someone related to you is going to commit a
For
fault.
instance, there's your employee and your employee insults a client and it's your employee. So it's the same
Right.
situation as if you had insulted the person. Insulted the
Right.
person.
And sorry that I disagree several times. Is I find it too extreme.
Okay.
Right. E says it is not always necessary to be guilty of some fault to be liable for a tort.
Oh, true.
Uh,
Yes, Tiana. I think it's true.
True. Very good. Yes.
Okay. Next one.
Next one.
Exercise two.
Here, exercise 2. Juan Ignacio, can you read the assignment
Yes.
in frame number 6?
Yes. Look at Anne Eddington's lecture notes on tortious liability again. Find the words or phrases in the notes that match each of the following meanings.
Maria, can you read the first one? Letter A.
Sorry, I was muted. Yes,
Very good.
the duty that every citizen owes to every other citizen according to the law of tort. The word or phrase is the duty of care.
Yes, yes, you're right. Yes.
The duty of care. Very good. Shall I write it down?
I write
I write it. Oh, okay. Maria does. Maria does.
Right.
Okay.
Duty of care. Right. Romina, can you read letter B?
Yes. The name for the general responsibility for harm caused to other people according to the law of tort. The word or phrase is
To other people according to the law of
The
tort.
name for the general responsibility for harm.
Responsibility, which is the responsibility.
Liability, puede ser.
Liability.
one is it?
Excellent. Yes,
Tortious.
Tatiana. You are almost a lawyer, Tatiana.
What did she say?
Liability, she says.
Liability. Very good.
Yeah.
Tortious liability or just
Tortious liability,
liability?
maybe also. Yes. Tortious liability.
Let's go with liability, which is the most
Simplest one.
simplest one, and I think is yes, the simplest one. Don't worry.
Okay. Next one.
Well, here in C, Juan Ignacio, can you read this one?
Yes. The tort of entering onto someone else's land or property without that person's permission.
What is that?
Trespass
It wasn't
to
in
the
the
land.
text. Trust.
Yes.
Yes, trespass to
It
land.
was in the text.
Trespassing.
Trespass.
Trespassing. I'm going to write it down. Don't worry.
Yes.
Which is the expression we use here for that word,
In
trespassing?
Spanish.
In Spanish.
Trespassing. It's trespassing. Ojo con la E. Trespassing.
Trespassing, yes.
Yes. In Spanish, what would it be? In Spanish.
Usurpación.
Usurpación o allanamiento ilícito.
De morada.
De domicilio, de morada.
Allanamiento de morada.
Yes.
Right.
Next one.
Trespassing, yes.
Yes.
Okay, so here we have the final listening activity. We are on time, so we can do it. We have 2 minutes. Oh. No, yes, I think we have. Right, so, Vicky, can you read the assignment?
Yes. Exercise 1. Listen to this professor who is giving her student a lecture. It is an introduction of the law of tort. Listen to the lecture and answer the following questions.
First of all, let's start reading some of the questions so that you don't get lost. Maria, can you read the first one?
Yes. The professor says that some people give the law of tort a different name. What is it?
Very good.
A different name.
Juan Ignacio, can you read letter B? What is the question?
What is the meaning of the word redress?
Oh, so we are going to see
Very
that,
good.
to
Very
know,
good.
get to
So,
know that.
but remember the definition that you and I give to the word redress is not the same as the one that the professor is going to give.
Okay.
So we
Beware
can
of
get
that.
the idea of the answer that we're going to listen, which is the basis of listening activities. You have to predict the answer, but we still don't know. So don't.
Okay.
Right. Let's just see. Tatiana, can you read it?
Yes. What do the majority of claimants want to when they bring an action to court under the law of tort?
Claimant. Right. Interesting. D, Romina, can you read it?
Yes, the professor says that damages are one form of redress that the court can offer to an insured party. What is the other remedy insured? What is the other remedy that she mentions?
So there's a she, the professor is a she, and
Yes.
there's another remedy. Okay.
Remedy. Yes, you should know that professor works for women and men. So
Okay.
there is no difference.
Oh, more questions.
Yes, it's another slide, another frame as well, more questions.
Okay.
And everyone, it's a long listening, so you're gonna have a great time.
Okay.
I always say that. What are the other remedy that she mentions? Right. Very good. I'm going to make
Now
it bigger. Vicky, can you read it?
Yes. How does the professor define the tort of nuisance?
Do we have an expression in Spanish with the tort of nuisance?
I know it.
Ruidos molestos.
Yes, exactly. That's nuisance.
No disturbios.
Olores también puede ser.
Yes. Well,
Tort
in
of
fact,
nuisance.
nuisance is una molestia menor. That's the translation. But the concept is used for ruidos, olores, that's nuisance. Daños en la vecindad, nuisance.
Right, nuisance. That is also another French word, but there's no need to look into it.
Okay.
Who else is there?
Don't
Maria,
be
letter
scared.
F.
Okay. What does the professor say is the correct term for a person's liability in the law of tort?
Right. Tatiana, letter G. Can you do it? Can you read it?
Yes. The professor mentions an automatic duty that the law imposes upon everyone. What is the name of this duty?
Mhm.
All right, so now you all know, you probably may think that is the duty of care, which is what we have
Probably,
been studying.
yes, the duty of care. Yes.
Probably. So let's
Yes.
see, what is the name the professor gives? Romina, letter 8, can you read it?
Yes. The professor mentions two ways in which a person has a duty under the law of tort not to harm another. One duty is not to harm a person physically. What is the other duty that she mentions?
Right. Well, I ran out of people. Okay, Maria, can you read letter I?
Yes, the professor mentions that the law of tort and the law of contract overlap in some ways. She gives an example of a company supplying something to a group of consumers that will lead to concurrent liability in tort and criminal law. In the professor's example, what did the company supply to the consumers?
Okay, and the final one, letter H. Juan Ignacio, can you read it?
Yes. How does the professor say that some legal commentators have described the law of tort?
Okay.
Very good.
We
I think
should
that's the
take a
final one.
picture. We should take a picture of the slides or the frames. Frame number 7 and 8.
Number 7 and 8, if you want, although I think I have here the maybe the file.
Okay.
I always upload the file as well with the PDF.
Okay.
I hope you enjoy because it's a lot of work uploading the files.
Oh, you are all the time making us
No,
guilty.
it's a lot of work cutting and pasting the files. That's
Okay.
why I make such emphasis.
Okay.
Language of contract law, yes. Language of law.
Well, go on, please.
Yes, I'm just trying to search for the file. Maybe I have it right here. No, it's not. Okay, so, well, maybe you want this to be shared.
Oh, sorry, my cat.
Do you like it this way?
Yes. Excellent.
All right, so I'm going to play the recording. Tell me if you can listen to it.
5B.
Yes,
The
yes.
Yes.
Very good. So
Yeah,
I'm
fine.
going to- Are you ready?
Yeah.
Unit 5B. The language of the law of tort. Unit listening.
Today's lecture is a general introduction to the law of tort. First of all, let's ask ourselves, what are the aims of this area of law? Why do we need to have a law of tort, or as some people call it, the law of obligations at all? Those are questions that really require a lengthy answer because the law of tort covers so many different situations in life. On a very general level, however, we can say that the law of tort is concerned with the idea of redress. Students often ask me for a precise definition of redress because it's not a word that you hear used in the street every day. I would say that redress means to remedy a wrong, to restore the balance of things. A person who has suffered a wrong wants to be put back in the situation that they were in before. A member of the public will usually describe this as a process of compensation rather than redress. This is probably because the claimant, in the vast majority of tort actions that come before the courts, is seeking monetary compensation for the wrong that he or she has suffered. To those in the legal profession, this monetary compensation is more correctly known as damages. So please don't confuse the two terms. Redress and compensation are quite different things. Let's stick with the idea of redress for a moment. We've established that monetary compensation is one type of redress. What else can the courts offer to the injured party? Well, in many cases, the claimant is not seeking money at all, but an injunction to prevent the occurrence of harm in the future. If we take as an example a case of the tort of nuisance, which is the tort of interfering with an individual's enjoyment of his or her land, you can clearly see that the defendant is engaged in a continuing act. Let's say the nuisance is one of noise. Damages are available to the defendant, but are clearly not the desired remedy for a claimant who is suffering over a long period of time. The claimant wants the nuisance to stop, and the obvious remedy is therefore injunction. So, having established that the law of tort is concerned with the redress and that this redress can take several forms, let's now turn to the question of liability in tort. We would correctly term this tortious liability. What is the scope of this liability in our legal system? It is absolutely impossible for every act in society that causes harm to another to lead the victim to demand a remedy. If, for example, I start a business such as a cafe in an area where there is already a cafe, and I provide a better service, then I have caused my competitor to suffer a loss. But should I be liable for that loss? Of course not. No reasonable person would suggest otherwise. So it is therefore a fairly easy matter to establish that not all losses or harm that a person suffers can be remedied. In general, the scope of tortious liability is as follows. The law says that I have an automatic duty of care towards other people in general. It doesn't matter who they are or whether or not I have any kind of relationship with them. I nevertheless have a civil duty not to harm them in any way. I am not allowed by law to hurt another person physically or to harm their reputation. This duty is independent of any kind of contractual agreement. The duty exists in the law itself and does not depend on the consent of the parties as it does in the law of contract. To give you an example, the law of tort says that I have an automatic duty not to trespass on your land. An automatic duty. The duty exists because the law says so and not because I have made any private agreement with you to undertake such a duty. Of course, in practical terms, there is often an overlap in any real-life situation between the law of contract and the law of tort. If we take the example of a company supplying a defective product to a group of consumers, this may result in concurrent liability in contract and tort. In other words, the company may be liable in both areas of law at the same time. The claimant may not, of course, recover damages twice. Similarly, tort and crime overlap. There are some torts that are also crimes, sometimes with the same names in both areas of law. For example, assault. Assault is both a crime and a tort. In some cases, the evidence from a criminal trial is used in a later civil action based on the same offence. Let's look at a criminal case involving a road traffic accident, for example. The state will bring a criminal prosecution if the driver of a vehicle caused an accident and he or she was breaking the criminal law. The evidence from the criminal case may then later be used as evidence of negligence in civil proceedings. The conclusion is to look at the law of tort as part of the wider law. Some legal commentators have somewhat unfairly termed it as the dustbin or the garbage can of the law of obligations. They mean it is there simply to deal with cases that other, longer established areas of law cannot deal with. I disagree. The law of tort exists for good reason, and it is an essential area of expertise for the modern lawyer.
He's so assertive, the person.
I truly love the actress.
Yes, it's assertive. So harsh, the person.
Very
Okay.
good. So, do you want to listen to it again, or we can just start working?
Tell us.
You tell me.
Romy, Juan, Maria, Tatiana.
Please, one more time.
Very good.
Okay.
Don't worry.
Okay.
Unit
note.
5B, the language of the law of tort. Unit listening.
Today's lecture is a general introduction to the law of tort. First of all, let's ask ourselves, what are the aims of this area of law? Why do we need to have a law of tort, or as some people call it, the law of obligations at all? Those are questions that really require a lengthy answer because the law of tort covers so many different situations in life. On a very general level, however, we can say that the law of tort is concerned with the idea of redress. Students often ask me for a precise definition of redress because it's not a word that you hear used in the street every day. I would say that redress means to remedy a wrong, to restore the balance of things. A person who has suffered a wrong wants to be put back in the situation that they were in before. A member of the public will usually describe this as a process of compensation rather than redress. This is probably because the claimant, in the vast majority of tort actions that come before the courts, is seeking monetary compensation for the wrong that he or she has suffered. To those in the legal profession, this monetary compensation is more correctly known as damages. So please don't confuse the two terms. Redress and compensation are quite different things. Let's stick with the idea of redress for a moment. We've established that monetary compensation is one type of redress. What else can the courts offer to the injured party? Well, in many cases, the claimant is not seeking money at all, but an injunction to prevent the occurrence of harm in the future. If we take as an example a case of the tort of nuisance, which is the tort of interfering with an individual's enjoyment of his or her land, you can clearly see that the defendant is engaged in a continuing act. Let's say the nuisance is one of noise. Damages are available to the defendant, but are clearly not the desired remedy for a claimant who is suffering over a long period of time. The claimant wants the nuisance to stop, and the obvious remedy is therefore injunction. So, having established that the law of tort is concerned with the redress and that this redress can take several forms, let's now turn to the question of liability in tort. We would correctly term this tortious liability. What is the scope of this liability in our legal system? It is absolutely impossible for every act in society that causes harm to another to lead the victim to demand a remedy. If, for example, I start a business such as a cafe in an area where there is already a cafe, and I provide a better service, then I have caused my competitor to suffer a loss. But should I be liable for that loss? Of course not. No reasonable person would suggest otherwise. So it is therefore a fairly easy matter to establish that not all losses or harm that a person suffers can be remedied. In general, the scope of tortious liability is as follows. The law says that I have an automatic duty of care towards other people in general. It doesn't matter who they are or whether or not I have any kind of relationship with them. I nevertheless have a civil duty not to harm them in any way. I am not allowed by law to hurt another person physically or to harm their reputation. This duty is independent of any kind of contractual agreement. The duty exists in the law itself and does not depend on the consent of the parties as it does in the law of contract. To give you an example, the law of tort says that I have an automatic duty not to trespass on your land. An automatic duty. The duty exists because the law says so, and not because I have made any private agreement with you to undertake such a duty. Of course, in practical terms, there is often an overlap in any real-life situation between the law of contract and the law of tort. If we take the example of a company supplying a defective product to a group of consumers, this may result in concurrent liability in contract and tort. In other words, the company may be liable in both areas of law at the same time. The claimant may not, of course, recover damages twice. Similarly, tort and crime overlap. There are some torts that are also crimes, sometimes with the same names in both areas of law. For example, assault. Assault is both a crime and a tort. In some cases, the evidence from a criminal trial is used in a later civil action based on the same offence. Let's look at a criminal case involving a road traffic accident, for example. The state will bring a criminal prosecution if the driver of a vehicle caused an accident and he or she was breaking the criminal law. The evidence from the criminal case may then later be used as evidence of negligence in civil proceedings. The conclusion is to look at the law of tort as part of the wider law. Some legal commentators have somewhat unfairly termed it as the dustbin or the garbage can of the law of obligations. They mean it is there simply to deal with cases that other longer established areas of law cannot deal with. I disagree. The law of tort exists for good reason, and it is an essential area of expertise for the modern lawyer.
Very good. So I hope you enjoyed it.
Yes,
I always hope you enjoyed it. So now let's go. Sorry, shall I continue sharing the PDF file?
Yes, please.
Just check.
No, así completamos el...
Yes, yes. Well,
Very
okay.
good. So
The prize.
I'm going to share. What am I supposed to share? All right.
Share the Jamboard.
Yes, sorry. Remember that it's not so easy.
So quick.
But we are seeing the Jamboard.
Yes.
Yes. Because I need to. All of this is for the recording. Always be considerate as regards the people who are watching the recording.
So we go to Jamboard.
Yes.
Okay.
Do you see it?
Number 7
Yes.
left, remember.
Frame number 7, yes.
7.
Right, so the professor says that some people give the law of tort a different name. What is it?
Law of obligations.
Law of obligations. Very good. You are right.
Okay, I did that.
Law of...
Okay.
Did you find it easy? I thought it was easy.
What do you say?
Yes.
Yes, she speaks fast. But
Usually,
it was
during
not
the exam,
difficult.
it's more difficult.
Yes.
Fast. Do you think it was fast? I thought it was rather fair.
It was clear, but was fast if you have to write.
Yes. You have
Right.
to write.
Very good.
Okay.
What's
the meaning of the word redress?
What's the meaning of the word redress? She gives a lot of definitions, and I still want to know. You tell me, what is the meaning of the word redress?
Maybe remedy of wrong and wrong act.
And to restore the balance of things.
Restore balance.
To restore balance. Very good. Is any one of you
No,
right?
but Tatiana is right. She said To remedy a wrong.
To remedy a
well.
wrong. Yes.
Okay.
Oh,
I think it's restore, no restored.
To restore.
Restore
Yes.
with an final E.
Okay,
But
you're right.
kudos to the one who wrote it down because very good.
Okay.
I
Restore.
have a
Restore
question.
balance.
Sorry.
Yes.
Part A. Yo escuché en lugar de law of obligation, yo escuché law of application at all. Maybe I.
Applications at all.
Application.
Sí, yo escuché application at all. Yo capaz yo escuché mal.
No, I
Applications
think.
at all.
Sorry, Tatiana, but I think. The ones who said law of obligations
Obligation,
are actually
not
right.
application.
I'm sorry.
Okay.
I'm
Number
sorry.
C.
Right, to restore balance, to remedy a wrong. Okay, both of them could be an answer, so don't worry. C, what do the majority of claimants want when they bring an action to court under the law of tort?
Monetary compensation.
Monetary.
Monetary compensation, yes.
I write it.
Write it down. Very good. Always remember it's to write down.
Yes, yes. Right. That's it. Another one.
Monetary compensation. Was there another? That's the majority because I think she said there was another reason
Or
people bring an
damages.
action. Monetary
Or
compensation,
damages.
it can be damage. Very good. The professor says that damages are one form of redress that a cause can offer to an injured party. What is the other remedy that she mentions?
I remember.
Yo escuché
An injection.
Injection, sí, injection.
Injunction.
Yes.
Very, very good to the ones who listen to that.
Yes, yes. That's it.
Very good. Injunctions. Do we use the same expression in Spanish? Do we have injunción?
No, no. Es un mandamiento que con una orden judicial de innovar o no innovar. That's injunction.
Injunction.
Todo eso. Bueno, injunction.
So it is mandamiento judicial para una innovación.
Remember that Spanish is a periphrastic language. Periphrastic
Yes,
means da
I know.
mucha vuelta para decir algo. Periphrastic language.
Yes, as a philosophy student, I know, and I wish they weren't so periphrastic.
Okay.
My God, it's so
Next
hard.
one. Friend number 8, please.
Right. E, how does the professor define the tort of nuisance? Can somebody tell me?
A long definition she provides.
It provides the definition that it's an interference to the enjoyment of a land or something like that.
Yeah, interfering with someone enjoying.
With someone.
I think she mentions the idea of interfering with a process of someone having to enjoy what you just said. Maybe their businesses, their lands, or it's like a disruption. You could say a disruption. Let's call it a disruption. But interference with you see, that's a way to make it easier. A disruption of everyday life, and disruption is a very formal term as well, so it is valid.
Disruptivo.
But you are right, interference with an enjoyment, or maybe with the enjoyment.
Okay. And she said that it not don't need some remedy. It need just to stop with for
enjoyment of a land. Okay.
With an all right, with an enjoyment of a land, or with the enjoyment of a land, right?
Okay. Next one.
Tell me, everyone, what does the professor say is the correct term for a person's liability in the law of tort? It's such a long question.
Tortious liability.
Tortious liability, very good. Who wants to write it down? Maybe I can do it.
I wrote it.
Right. Always remember to click out of the box.
Okay. Another one?
And people, an advice for the examination as well is when you're being asked something, give a full answer.
Yes. That's why I said she says that. She
says that the correct term for a person's liability in the law of tort is a tortious liability. That's the full answer.
Yes.
The professor says that the correct term for liability in the law of tort is tortious liability.
Okay.
Very good. D. The professor mentions an automatic duty that the law imposes upon everyone. I love the word imposes.
Imposes on.
What is the name of the duty? This duty.
Duty of
care.
Of care, exactly.
Duty of care. Yes, that was easy.
Yes.
Right.
Okay.
The 8. The professor mentions 2 ways in which a person has a duty under the law of tort not to harm another one. Not to harm another. One duty is not to harm a person physically. What is the other duty that she mentions?
Don't harm reputation.
Yes.
Defamation.
That one.
Can you repeat?
Not to harm the reputation of someone.
Not to harm the reputation. Very good.
Yes.
Yes. The reputation of
someone. The reputation of someone. Very good. Okay.
So letter I, she says the professor mentions that the law of tort and the law of contract overlaps in some ways. She gives an example of a company supplying something to a group of consumers that will lead to concurrent. I love that one. Concurrent liability in tort and criminal law. In the professor's example, what did the company supply to the consumers? It's such a long question.
What
Can you repeat?
Defective products.
Defective products. Defective is such a formal expression. You're gonna love it.
You may also say faulty goods.
Faulty goods, even better.
Good. Yes, that's another one. She doesn't say so, but it's faulty goods.
It could be faulty goods.
Faulty goods.
You should know, everyone, that in listening sometimes it can be useful to use short expressions to mean the same answer, and so you don't have to write so long.
Okay.
So many things. Write down so many things.
Okay.
So Jay, how does the professor say that some legal commentators have described the law of tort? Sorry, I think someone is Vicky has to go.
Okay, Vicky, go.
Okay, Vicky.
Thank you very much. Bye-bye, Vicky.
Very good.
Bye.
Last
how does the professor say
go.
that some commentators have described the law of tort, and we are finishing here right on time because I'm a genius.
Tell us. The commentators.
You tell me. She said that some legal commentators have described the law of tort in. There you have it. Look here. I'm going to teach you this word. Detrimental ways.
I heard something like garbage can.
Yes, the garbage can.
Yes, the garbage can.
Yes.
No, that's detrimental ways is not the answer.
No, I know.
That's but it could be because they said it was the garbage can of what?
Of the law.
And she says that she doesn't agree with that.
Of the law of obligation.
Yes.
Very good. So they call it the garbage can.
Yes. Okay.
I'm not so sure. I think that wasn't acting. That was the actress.
Yes, of
talking
course.
about it. All right, everyone. So we finished right on time. I hope you enjoyed it.
Well, we will
Next,
upload all of this. And Juan continues studying, please.
Yes.
And
Yes.
next week we will
I'm going
prepare
to
another
start
unit,
skipping
remember.
ahead. So next week we're going to start learning with Unit 6.
Yes, yes, yes.
I hope you
Yes.
enjoyed the tool
need to go
about
ahead.
this unit because it
Yes.
was the only lesson.
Well,
Right.
bye.
I think it was full. It was a lot of work on your part.
Yes.
So
Yes.
congratulations as well.
Thank you, Tatiana. Thank you, Maria, Romina, Juan.
Very
and
good.
Valeria.
Goodbye. I'm gonna stop the recording.
Bye-bye.
Bye. See you.
You.
See you.
Bye bye.